Ascension to New Plains: The Impact of Bryan v. Itasca County and the Native American Gaming Industry. In the northern plains of Minnesota, a man surveyed a mobile home on land held in trust by the federal government. It was the spring of 1972. 4 years later, the Supreme Court made the landmark decision that created a nationwide tribal gaming industry. Helen and Russell Bryan were two Ojibwe Native Americans who had lived together on the same land on the Leech Lake Reservation for 15 years. Helen had lived there her whole life. In 1972, the Bryans' new mobile home was surveyed and they received a series of tax notices from Itasca County for the first time in their lives, totaling up to $147.95. The couple was baffled. The series of taxes was more than the cost of their monthly mortgage. Helen was the sole provider for her 5 children, and while this amount may seem small today, it was unfeasible for them.
They were not a wealthy family, but they went down to the legal aid office and they said, hey, we got this tax notice. Can the state tax us because we're Native Americans living on an Indian reservation? And that's what launched the case.
The Leech Lake Reservation Legal Services Project, the local legal aid office, took the Bryans' case to court, claiming that the state did not have the authority to impose personal property taxes on land held in trust. One of the struggles the Bryans faced was that through each step, they had different representation.
The lawyer that brought the case ended up leaving that office, and another lawyer took over and then litigated it for a while, and then that lawyer left. And so at every stage, it was a different lawyer.
Despite this challenge, they were able to ascend through multiple levels of the court system. In the beginning, the district court denied the claimants, siding with the state. The Bryans then appealed the case, and their contention was denied by the Minnesota Supreme Court. They petitioned yet again, this time getting their case moved up to the United States Supreme Court.
The court sustained the lower court decision imposing granting a judgment for a tax on a mobile home owned by an Indian which is placed on trust land.
If I live in Itasca County and don't pay my taxes, doesn't either the county or the state have a cause of action against me for failure to pay the taxes?
The respondent's position in this case, of course, is that the Public Law 280 does authorize the states to tax Indians on Indian reservations, with the exception that is specifically spelled out in the law itself.
We therefore reverse on the ground that the state did not have authority to impose a property tax on the petitioner's mobile home.
In 1976, in a unanimous opinion delivered by Justice William J. Brennan, the court established that states did not hold the right to impose civil regulatory laws on reservations. But the progress didn't stop there. "11 years later, a new case emerges in California that solidifies the future of tribal gaming in the United States. California v. Cabazon Band of Mission Indians overturned existing laws that restricted the gaming industry on Native American reservations. The main argument being that the laws restricting the gaming industry were civil regulatory laws, those explicitly ruled against in the Bryan v. Itasca County case. As a result, tribal governments were given the right to ownership of the gaming industry through the precedent set in the earlier case. In 1988, U.S. Congress passed the Indian Gaming Regulatory Act, defining the scope of Native American power over gaming. Even though they were given control over the gaming industry, the legal obligations to the American government remained. Through the attempted taxation of one reservation property, tribal-owned gaming has now become a huge, yet unevenly distributed power that comes with significant responsibility. Tribes have the exclusive right and responsibility to conduct, license, and regulate gaming activity under federal oversight. The industry is growing rapidly and increasing in complexity with multiple growing facets. In 2019, 522 tribal gaming facilities employed approximately 200,000 people and generated almost $35 billion in annual gross revenue, and it keeps growing.
Well, last year, Indian gaming brought in $40 billion. A lot of states use their money from their lotteries to support education, for example, which is I've always thought is kind of ironic because if they were really successful in educating people, people wouldn't play the lottery.
In the words of David Truer, like all American avenues to wealth, casinos privilege the few and leave out the majority. Fewer than half of the 511 federally recognized tribes own and run gaming operations. In 2002, 12% of tribes earned more than 65% of gaming revenue. In one tribe in Minnesota, the unemployment rate is 99.2% because each member is receiving upward of $1.08 million annually. However, this is not the case for most casino-owning tribes. While some tribes make so much that they can give per capita distributions to individual members, most tribes do not allot their casino earnings to their members, and instead put it towards infrastructure and social services. Casino revenue is oftentimes used for hospitals, law enforcement, education, and healthcare, usually going towards many of the things tax money supports in the rest of the U.S. Casinos also provide jobs not just for tribal members, but also, through the infrastructure they create, make more jobs in tribal government services. Tribal gaming has been shown to increase employment and wages by about 5%. However, the national unemployment rate for Native Americans continues to increase, reaching 19% in 2010, showing the significant disparity between tribes with casinos and tribes without casinos. Because the financial success of the casino can correlate with the success of the indigenous community, tribal economic success varies greatly.
It's just like America. Connecticut is a very wealthy state. Minnesota is fairly wealthy, but there's Mississippi and Alabama that are very, very poor states. And, Connecticut and Minnesota don't share their money with Alabama and Mississippi. And so, yeah, it's just like America. It's distributed very unequally.
Having domination of the gaming industry is an important right because it gives tribes a huge revenue source that can be used to lessen the economic disparities Native Americans face. Some restructuring can help tribes get ahead, and many have started looking into the potential of the cannabis industry, wondering if it will be the next rising star in the lifestyle economy. Solidifying tribal sovereignty, Bryan v. Itasca County gave the right and responsibility of the gambling industry to Native Americans, which empowered them with crucial access to the U.S. economy. Their disproportionate representation in the justice system, their missing and murdered Indigenous women, lack of access to health care, higher rates of alcoholism, depression, and suicide are just the beginning of the long-lasting impacts of the historic crimes against them. This case gave Indigenous Americans hope for the possible gain of economic and social influence despite the history of dismantling violence and destruction waged against them.